Hello everyone, I am Tanya Pandey and I welcome you to episode 2 of LiveLaw's limited series on the most important judgments of 2021. If you like our videos, do subscribe to LiveLaw because we also bring updates of important judgments being delivered every week. Without further ado, let's get into today's episode. A bench of Justices Sanjay Kishan Kaul and R. Subhash Reddy in Bajaj Allianz General Insurance Company Private Limited versus Union of India issued a slew of directions regarding process of disbursement of compensation, as well as expediting the matter before the motor accident claims tribunals across the country. According to these directions, jurisdictional police station has to submit an accident information report about the accident to the tribunal and insurer within first 48 hours either over email or a dedicated website. They were also directed to submit a detailed accident report to them within 3 months. The Supreme Court on 18th March set aside a Madhya Pradesh High Court's judgment in Aparna Bhat versus State of MP, wherein the court had imposed a bail condition upon a person accused of outraging the modesty of his neighbor to request the victim to tie a Rakhi around his wrist. The bench of Justices S. Ravindra Bhat and A. M. Khanvilkar said that the act is not a minor transgression that can be remedied by way of an apology, tying a Rakhi, or presenting a gift to the survivor, or even promising to marry her, as the case may be. The court issued a set of guidelines to be followed by courts while dealing with sexual crimes and held that the use of reasoning or language which diminishes the offence and tends to trivialize the survivor is to be avoided under all circumstances. The court also observed that each high court should formulate a module on judicial sensitivity to sexual offences to be tested in the judicial service examinations. It also directed the Bar Council of India to take steps to include such courses as part of LLB and AIBE syllabus. In a significant judgment, the Supreme Court on 19th March overruled its 2019 verdict in the case of Messrs. NV International versus State of Assam, which had strictly held that a delay of more than 120 days in filing of appeals under Section 37 of the Arbitration and Conciliation Act cannot be condoned. The bench of Justices R.F. Nariman, B.R. Gavai and Rishikesh Roy has now held that delay beyond 90, 60 or 30 days for filing appeals under Section 37, depending on the forum, can be condoned. But such condonation of delay should be an exception and not the norm, having regard to the objective of the Arbitration Act for expeditious settlement of claims. Section 37 of the Act provides appeals against orders under Sections 9, 34, 16 and 17 of the Act. No specific period for appeals is provided under Section 37, unlike Section 34. The Supreme Court in Small Scale Industries Manufacturers Association versus Union of India directed that there should be no charging of compound interest, interest on interest or penal interest on the installments which were due during the loan moratorium period from March 1st to August 31st, 2020 on any borrower, irrespective of the loan amount. If such interest has already been collected, it should either be refunded to the borrower or adjusted towards the next installments. In 2020, the Centre had taken a decision to allow waiver of interest in 8 specified categories for loans up to Rs 2 crores. The Supreme Court observed that there is no rationale in the Centre's policy and termed it to be arbitrary and discriminatory. A bench of Justices D.Y. Chandrachud and M.R. Shah declared that the evaluation criteria adopted by the Indian Army to consider the grant of permanent commission for women officers to be arbitrary and irrational. The court directed the Army to reconsider the pleas of women short service commission officers for grant of permanent commission within 2 months in accordance with the fresh directions issued by the court. The Supreme Court quashed the FIR registered against Shillong Times editor Patricia Mukim over a Facebook post on violence against non-tribal people in Meghalaya. The bench of Justices L. Nageshwar Rao and S. Ravindra Bhat referred to Sections 153(a) and 505(1)(c) of the Indian Penal Code and observed that only where written or spoken words have the tendency of creating public disorder or disturbance of law and order or affecting public tranquility does the law need to step in to prevent such an activity. The court allowed the appeal filed by Mukeen, challenging the Meghalaya High Court's order, which had dismissed her plea to quash the FIR. The Supreme Court refused to stay the release of the fresh set of electoral bonds from April 1, 2021 for the assembly polls in West Bengal, Kerala, Tamil Nadu, Assam and Puducherry. The court dismissed the application filed seeking stay of the bonds. The bench of then CJI S.A. Bobde, Justice A.S. Bopanna and V. Ramasubramanian held that since the bonds were allowed to be released in 2018, 2019 and 2020 without interruption and sufficient safeguards are there is no justification to stay the electoral bonds at present. In a big win for Tata Sons Limited, the Supreme Court on 26 March allowed its appeal against the order of the National Company Law Appellate Tribunal, which had ordered to reinstate the ousted chairman, Cyrus Mistry. The court ruled on all issues in favour of Tata Sons Limited and set aside the NCLAT order. A three-judge bench of then Chief Justice of India S.A. Bobde, Justice A.S. Bopanna and Justice V. Ramasubramanian found that Mr. Mistry's removal did not amount to oppression or prejudice and that his reinstatement on the boards of various Tata Group companies was out of question. The bench also said that it was open for Tatas and Mistry to work out their separation terms. The Supreme Court refused to grant relief in a petition challenging the detention of Rohingya refugees in Jammu and the move to deport them back to their parent country, Myanmar. The court refused to order the release of nearly 150 Rohingyas detained in the holding centres in Jammu and allowed their deportation to their parent country as per the procedure of law. The court observed that the right not to be deported is ancillary to right to reside or settle in any part of the territory, which is guaranteed under Article 19(1)(e) of the Constitution, which is a right available only to citizens. The Supreme Court in Messrs Niharika Infrastructure Private Limited held that the High Court, while dismissing or disposing of the quashing petition under Section 482 CRPC or under Article 226 of the Constitution of India, shall not pass order of not to arrest or no coercive steps, either during the investigation or till the investigation is complete or till the final report or charge sheet is filed under Section 173 CRPC. The bench of Justices D.Y. Chandrachud, M.R. Shah and Sanjeev Khanna observed that when the investigation is in progress and the facts are hazy and the entire evidence or material is not before the High Court, the High Court should restrain itself from passing the interim order of not to arrest or no coercive steps to be adopted, and the accused should be relegated to apply for anticipatory bail under Section 438 CRPC before the competent court. The Supreme Court in Asset Reconstruction Company India Limited versus Bishal Jaiswal held that entries in balance sheets can amount to acknowledgement of debt for the purpose of extending limitation under Section 18 of the Limitation Act. In holding so, the bench of Justices R.F. Nariman, B.R. Gavai and Rishikesh Roy set aside a judgment of the full bench of National Company Law Appellate Tribunal in the case of V. Padmakumar versus Stressed Assets Stabilization Fund, which had held otherwise. A constitutional bench of the Supreme Court on 16th April issued a set of directions to expedite the trial of check dishonor cases under Section 138 of the Negotiable Instruments Act. The order was passed by a bench comprising of then Chief Justice of India S.A. Bobde and Justices L. Nageshwar Rao, P.R. Gavai, A.S. Bopanna and S. Ravindra Bhat. The court also directed that magistrates have to record reasons before converting trial of complaints under Section 138 of the Negotiable Instruments Act from summary trial to summons trial in exercise of power under the second proviso to Section 143 of the Act. Expressing grave concerns at the mounting vacancies of High Court judges, the Supreme Court emphasized that the central government should proceed to make appointments immediately after the Supreme Court Collegium has cleared the names. If the government has any reservation over the Collegium recommendations, it should send back the names with a specific reason for reservations. Once the Supreme Court Collegium reiterates the names, the Centre should make the appointment within 3 to 4 weeks of such reiteration. The Supreme Court directed the High Courts to adopt the draft rules of criminal practice which had been prepared by Amici Curiae Senior Advocates R. Basant, Siddharth Luthra, and Advocate K. Parasaran, within a period of 6 months. The bench of then CJI S.A. Bobde and Justices L. Nageshwar Rao and S. Ravindra Bhat directed the High Courts to take expeditious steps to adopt the said draft rules and to ensure that existing rules are suitably modified within a period of 6 months. A bench comprising of then Chief Justice of India S.A. Bobde and Justices Sanjay Kishan Kaul and Suryakant passed a slew of guidelines regarding the appointment of ad hoc judges in High Courts under Article 224 Capital A of the Constitution to tackle the problem of mounting case arrears in High Courts. Article 224A enables a Chief Justice of a High Court, with the previous consent of the President, to request a former High Court judge to sit and act as a judge of the High Court to hear cases. The provision has been invoked very rarely in the judicial history of India. The bench of Justices D.Y. Chandrachud and M.R. Shah doubted earlier judgments which interpreted Section 3, Subsection 2, Clause 5 of the SC/ST Act to mean that the offence should have been committed only on the ground that the victim was a member of the scheduled caste. To deny the protection of Section 325 on the premise that the crime was not committed against an SC and ST person solely on the ground of their caste identity is to deny how social inequalities function in a cumulative fashion, the court said. The Supreme Court, while issuing directions to reduce delays in the execution proceedings, observed that an executing court must dispose of the execution proceedings within 6 months from the date of filing, which may be extended only by recording reasons in writing for such delay. The bench, headed by then CJI S.A. Bobde, asked the High Courts to reconsider and update all the rules relating to execution of decrees made under exercise of their powers under Article 227 of the Constitution of India and Section 122 of CPC within 1 year of the order. The Supreme Court in Indian School Jodhpur versus State of Rajasthan held that state's regulation of profiteering by education institutions cannot be held to be violating the management's fundamental right to trade and profession under Article 19(1)(g) of the Constitution. The court, however, upheld the constitutional validity of the Rajasthan Schools Regulation of Fee Act 2016 while reading down Sections 4, 7 and 10 of the Act. The Supreme Court bench of Justices D.Y. Chandrachud and M.R. Shah on 4th May 2021 struck down the West Bengal Housing Industry Regulation Act 2017, holding it to be unconstitutional in view of the 2017 Real Estate Regulation and Development Act, RERA, which is the central legislation on the identical subject matter. However, with a view to prevent any chaos in the real estate industry in the state, the court, in exercise of its powers under Article 142, clarified that all sanctions and registrations previously granted under the HERA prior to the date of this judgment shall continue to prevail. With this, we've come to the end of Part 2 of the most important Supreme Court judgments delivered in 2021. Stay tuned for the next episode and don't forget to like and share this video if you found it useful. I am Tanya Pandey for LiveLaw and you're watching Courts This Week. I wish you a spectacular day ahead.